I'm Bill Daniels, and I'm an attorney here in Southern California. I'm also one of the founders of the Loyola Law School Advanced Trial Skills Institute. Today we're going to talk a little bit about depositions. So, what is a deposition? A deposition is a formal question and answer session where attorneys will ask you questions and you'll be testifying under penalty of perjury. Even though depositions usually take place in informal settings like conference rooms or offices, the testimony that you give has the same force as it would if you were testifying in front of a judge and a jury at the time of trial. So you need to prepare carefully for your deposition and give the best testimony that you possibly can. A deposition is a formal question and answer session. During your deposition, attorneys will lead you through testimony in your case. If you are a party, meaning a plaintiff or a defendant, then the attorneys will be asking questions that are meant to probe for flaws in your case. If you're a witness in someone else's case, then the attorneys will be looking for testimony that will help them with their own client's case. The questioning attorneys are looking for flaws in your testimony that will undermine your case. Either way, so long as you follow some simple guidelines, you'll be able to sit down and testify without any fear.
Rule number 1. Always tell the truth.
At your deposition, there will be a court reporter who will take notes on a stenographic machine about everything that's said in the room. That same court reporter will have you swear an oath under penalty of perjury where you will agree to testify truthfully to the best of your ability under penalty of perjury. Always tell the truth because you will be sworn to tell the truth under penalty of perjury. You need to take the oath seriously. If you don't testify truthfully and you are caught, it will certainly hurt your case, and in some jurisdictions there can be other penalties as well. What the oath doesn't mean is that you have to have superhuman recall or know the answer to every question. If you don't know the answer to a question, it's quite all right to say, I don't know. If you don't recall the answer, it's okay to say, I don't recall. What you don't want to do is testify about something when you really don't know the answer. If you make a mistake about a material fact in your case, it can come back to haunt you. So be careful.
Rule number 2. Listen to the question.
When giving testimony, always listen to the whole question before you give your answer. If you haven't heard the whole question, don't answer it. If you don't understand a question, it's quite all right to say, I don't understand. Let the attorney clear it up and answer when you understand what's being asked. Don't be afraid to ask the lawyer to repeat or clarify questions you don't understand.
Rule number 3. Do not speculate or guess.
You should only testify about things that you know. You should not speculate or guess. You may, however, be required to provide estimates, so you need to know the difference between speculating and estimating. Well, if I was to ask you, how big is the TV screen that you're watching this on? You can give me an estimate because you can see the television screen and you have experience with units of measurement. But if I was to ask you, what do I have in my pockets? You'd have to speculate or guess. So now you know the difference between the terms, and you should also keep in mind that if you don't know the answer to a question, always feel free to say, I don't know, or I can't recall, or even, I can't answer that question because I would have to speculate. Let the attorney ask the next question or clarify. Never speculate or guess.
Rule number 4. Do not volunteer information.
It's important not to volunteer information during a deposition. The attorneys are only entitled to answers to the questions that they ask, and if you volunteer, you might disclose something that'll hurt your case and that wouldn't have been known if you hadn't volunteered. Also, if you volunteer a lot, it will definitely make the deposition longer. So just answer the questions. Answer the questions, but don't volunteer information.
Rule number 5. Do not be afraid of mistakes.
If you make a mistake, don't worry. Just correct the answer as soon as you can. The law recognizes that we're all human, and your attorney can help you to correct the record. However, if you make a number of mistakes during your testimony, expect the other side to argue that you're not a reliable witness. So it's important to come to your deposition prepared and to testify as accurately as you can. If you make a mistake, tell your attorney at the first available opportunity.
Rule number 6. Relax. Do not be afraid.
Again, a deposition does not require you to be perfect. You don't need to remember every detail perfectly by memory. As long as you just answer the questions truthfully and only answer the questions that are asked, you really have nothing to fear. You don't have to know every detail. There is nothing to fear or be anxious of if you answer the question truthfully. I hope you find these pointers helpful. Your own attorney will explain the deposition process in more detail and answer any questions you have. So good luck in your case.